Every business, regardless of its size, must provide its employees with safe working conditions. And considering the range of potential hazards from asbestos to slippery stairs to excessive noise, that can be difficult for a small business. And why should everyone be so concerned about job safety and health? Because each year, approximately 6,000 employees in this country die from workplace injuries, while another 50,000 die from illnesses caused by exposure to workplace hazards. In addition, 6 million workers suffer non-fatal workplace injuries at an annual cost to U.S. businesses of more than $125 billion. Standards and rules for safe working conditions, tools, equipment, facilities, and processes are set by the Labor Department's Occupational Safety and Health Administration, OSHA. OSHA standards apply to every private employer with one or more employees, except for those in industries covered by other federal job safety legislation. Today, roughly 93 million employees across the country are protected by state and federal OSHA programs. But even with adequate safety measures, accidents do happen. Today, the Insider Exclusive goes behind the headlines in this special Safety on the Job, the Tim Bacon Story, to examine how Bob Pahlke, partner at Robert Pahlke Law Group, and Robert Hippe successfully got justice for Tim. On July 28, 2003, iron worker Tim Bacon was on the second level of a 4-story stairwell when a deck plate fell from above, striking his self-retracting lifeline. Tim plummeted 12 feet to the deck below and suffered severe injuries, causing paralysis for the rest of his life. The self-retracting lifeline was designed to break its line to prevent users from falling if it sensed a sudden acceleration. At his trial in January 2008, Tim lost on the grounds that there was insufficient evidence as a matter of law as to the existence of an unreasonably dangerous defect in the product as it relates to its warnings, and the court dismissed the case. But that did not deter Bob Pahlke in the least. He appealed that decision, and fortunately, the appellate court reversed the decision and remanded it for a new trial, but only on the issue of whether the self-retracting lifeline was defective and unreasonably dangerous due to the insufficient warnings. Bob faced tremendous challenges in successfully proving this case, and in this Insider Exclusive special, you will see for the first time ever how Bob and Robert used key testimony of the defendant's own in-house engineer and of the safety engineer that helped win this case for Tim Bacon. It only took approximately 8 hours of jury deliberations before they came back with a record verdict of over $21 million. Bob has earned a reputation as an unyielding country lawyer who repeatedly represents individuals and families against large corporations and repeatedly wins. He has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Scottsbluff, in Nebraska, and across the nation. He's a past president of the Nebraska Association of Trial Attorneys. Bob has built a successful reputation nationwide by consistently winning cases other law firms have turned down. And his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. Hi, I'm Steve Murphy, and this is the Insider Exclusive, live from Scottsbluff, Nebraska, at the law offices of Robert Pahlke Law Group. It is my great pleasure to introduce Bob Pahlke to the show. Welcome to the show, Bob.
Thank you, Steve.
Tell our audience a little bit about your firm. What kind of law do you practice?
Our firm does personal injury work, Federal Employer Liability Act cases involving railroaders been injured, product liability, some medical malpractice, and some occasional class action work.
And you've been practicing here in Scottsbluff about 30 years, haven't you?
A little longer than that. Actually, since November 30th of 1976.
We are going to be discussing a case, the case of Tim Bacon, a person who was injured on the job. And before we get into the actual case, I want to bring on your co-counsel, Bob Hippe. Welcome to the show, Bob.
Thank you.
Let's get into this case about Tim Bacon. Tell us the facts of what happened to Tim.
On the Quest Center, he was working on a fire escape, and things often get a little skewed and screwed up in construction, and so something was out of sequence. And what was out of sequence was they were putting in deck plates down the road as opposed to as the building was being constructed. And so the plan that the bosses and other folks had was to use a crane to lift deck plates, which are about 12 feet long and 24 to 30 inches wide, up the top of the 4th story, and the plates being longer than the available space, they had to tip them by the toe and then move them forward and down to every level, and they did that successfully with the first load. And they had one strap around it. So Tim is on the 2nd story, 2nd floor, and he is working with a SRL, self-retracting lifeline, that's attached to a beam to provide him safety.
And that is used in case he falls, correct?
In case he falls, that's the fail-safe.
Right.
And so while his attention is devoted to try and removing the strap from the previous load, unbeknownst to him, others, the crane company and his supervisors, are bringing in another load. And they bring it over the top, and they tip the toe of the load. And then instead of it working like the previous load, it swings around. And then the plates begin to fall, initially one at a time, kind of like cards in a deck.
Right.
And he gets an instant of a warning, and he immediately reacts, and he sees this panel coming, 12 foot long, 140 to 200 pounds, and he brushes it off with his hand, and he saves the life of the man below. And then the next one, or the next one after that, hits his lifeline and swings him out. Instead of arresting his fall, he plummets all the way to the bottom of the steel deck and breaks his back.
So they were actually doing 2 jobs at once, and they should not have been lifting these plates in place while these people were down below, just so this wouldn't happen, right?
That's one of the problems, and that was one of the challenges of the case.
Okay. And what happened to Tim?
Tim suffered what's called a burst fracture of the T12, the thoracic vertebra. And the hardware they had to put in him initially was pretty dramatic. And then after that, that surgery failed, and he began to lean forward about 70 degrees. This time they took rods essentially from the top of the spine all the way to the bottom of the spine. And had they not done that, he would have probably torn his aorta and died.
He must be in tremendous pain all the time.
He testified that in about 7 years, one time, for 5 minutes, he was laying in bed, didn't have pain, and he was afraid to move, he was afraid to breathe, because he didn't want the pain to come back.
Now, this case has an interesting story behind it, because he initially sued whom?
He initially sued Kiewit, which provided the crane and the crane operator. He sued Ridgetop, which was the parent company of his employer, which had responsibility for safety.
Yeah.
And the defense tried to bring in the employer for
Right.
the actions that they committed.
And he lost initially, didn't he?
He was able to resolve the claims against the crane company and the safety company, but he tried it for 5 days after those companies were out, and the judge directed a verdict against him.
Now, you appealed the case, right?
It was appealed before we got in, but the judge could probably describe that better than me.
Yeah. Tell us about the appeal.
Well, the great mystery in Mr. Bacon's case was whether he was hurt on account of this lifeline failing to work and him hitting the deck.
Or the hit, or the thing landing on top of him.
Or, according to the defense theory, or whether this self-retracting lifeline got overloaded by the weight of a bunch of deck plates that came down with him. That was a great mystery of the case. And it had been tried once. It went up on appeal, and on appeal it was sent back for another trial after Mr. Bacon had been legally kicked out of court.
And as I read this, it was sent back on the issue, only the issue, whether or not the SRL, the self-retracting line, was defective and unreasonably dangerous due to insufficient warnings.
So it was a
What does
warning.
that mean in simple English?
Well, it was a warnings case, and a warnings case always has the challenge of whether if the warnings had been given, if there would have been a different outcome. In law, we call that the causation issue.
Right.
And so this case had a lot to do with causation, which had to do with this mystery I mentioned of whether he was hurt because it didn't work or simply because it was overcome by weight.
Now, on the second go-around, second trial, was this mystery solved?
The jury solved the mystery.
Okay,
yes.
let's talk about some of the issues and the problems and the hurdles you had to have in presenting this case to the jury so they could solve the mystery.
First of all, it was just to explain a complex operation of building a building, what's involved for the ironworkers that are there that put their life on the line when they stand up high and hope that if anything goes wrong, that these protective devices will work, and in this case it didn't.
One of the challenges, Steve, was that how do we get them not to jump just solely to the crane company or the safety company that could have done things differently. And one of the things we did, we used some analogies in the jury selection. You know, if you're in an elevator and the power goes out, you expect to plummet all the way to the bottom. You know, if your son has a fight with his girlfriend and somebody runs a red light, do you expect the airbags to work? You know, kind of the backup safety system. You know, if there's a parachute and a plane, the engine dies, and the man jumps out, does the parachute, if it doesn't open and he dies, what is the cause? Are there two causes? Can you allocate? I mean, can you consider the second cause? And so that was one of the challenges that we talked about, and we asked them to do their job so the judge could do his job in allocating at the end of the case.
How did you actually explain that to the jury so they would be able to come back with the kind of verdict that you got?
Quite a bit visually. There were a lot of demonstrations, photographs, mock-ups of what the scene looked like, witnesses that were able to describe where they were and point out things in these mock-ups that we had in the courtroom.
Now, you had some other problems too. Some of your employee witness were not available, correct?
Yes. We had an employee witness who was the man on the third story who was not available. He had been charged with and convicted of a felony and was in prison at the time of the trial.
And even if you had been able to get him there, I'm sure the defense would have used the fact that maybe this guy is not of the greatest character, right? So he wouldn't make the greatest witness. How did you overcome that?
Well, what we did is we just owned up. And we had a history of owning up in this case, stepping up to the plate. And we told him, started talking about in jury selection, you know, if there's a witness who has a felony, can you listen to the evidence?
Yeah.
And they said they could.
What were some of your key winning points, if you will, in your strategy to win this case? For example, you talked about your in-house engineer. He kind of helped you in a way, didn't he?
Well, he wasn't an in-house engineer, but he was a safety engineer. And he helped explain how he had never seen, and one of their defense was, you know, we never saw this happen. We never heard of this happen. We go to seminars, international seminars. We didn't know that if the lifeline got hit, even a glancing blow, that could fail catastrophically unless it was overloaded. And when he understood the case, he was surprised, and then he began to teach his safety classes. This is what can happen. You need to account for this.
So in other words, there were some possible scenarios that the manufacturer had never even considered. And because of those possible scenarios, they were also responsible and liable for them too, weren't they?
That's an interesting question. Our co-counsel, Brittany Shutkowski, took the deposition of the company employee who supposedly knew the most. And she said, do you warn on the device that if something hits a lifeline, it can fail? No. Do you warn if something hits a lifeline that it can fail? Do you put that on the manual? No. Why don't you do that? And what he said was, it's a hazard that's not of a high enough occurrence rate, I guess, that it would be a concern that we would want to warn about on the device or the manual. Well, it was a concern that Tim Bacon would have liked to have known about.
Right.
It was of high enough, and they tried to say, we never had this experience, but when you say something has an occurrence rate, to us, that means it occurs.
Right. I really enjoyed reading that about the case because you're admitting it could occur, but it's not a high enough incident where we need to take it into consideration. But this case proves the opposite of that, doesn't it?
It's a perfect example of that. Another challenge we had, too, was that the plaintiff's expert witness that explained how this precisely happened and how the device failed had suffered an aortic aneurysm
Right.
between trials, and he was unable to attend.
And so what did you do to substitute
So
for
his
him?
testimony had to be read in. One person acted as the witness, and I acted as the attorney asking questions. And we used the devices in the courtroom a great deal to point out how he was able to explain what actually happened and how the device failed, and that hurt Mr. Bacon.
The jury was out, what, 8 hours? And they came back with an amazing verdict, didn't they? What was that verdict?
$21,131,633.
You remember every single number, don't you? Were you kind of shocked at that number?
Yes and no, but not so much, because we thought we'd put on a good case. We'd given a lot of thought to this case. We had figured out how we're going to present it, how we're going to structure it, how we're going to sequence it, and what we're going to argue. And one of the powerful pieces of testimony in this case concerning the damages, the spine surgeon, a doctor that trained in South Africa, was from South Africa, testified because of the nature of his particular injury, not just a typical paraplegic. He had a clonus injury, and that meant that he wouldn't have spasms in his legs. So sometimes that's good, sometimes that's bad, but that made him really susceptible to pressure wounds that can start from the bone, work all the way out.
Yeah.
And he said if that happens, he's at risk for becoming a man in a casket, because we may have to amputate at the pelvis.
And
if
he still suffers that risk today, doesn't he?
He does. And he said if he becomes a man in a casket, or man in a basket, he may be a man in a casket. So it is a grave risk that Tim has. He guards against it well, but
Trying to prevent any kind of injuries to that part of his body, correct?
yeah. And another part of why I think we were successful is because the jury heard the testimony from another man how Tim had saved his life
Yes.
in this deal. And he also, after this, began to design and develop a lift that cost a third of the money and would work when it was raining. He got stranded outside in the rain for 8 minutes beside his vehicle.
Wow. A lot of people are injured on the job. When you're injured, what are some common things? What are some things you should do immediately?
Well, I think first you document what happened. Make sure you take records, pictures, whatever, and promptly make a claim to your employer that this has happened, and hopefully get the investigation started early.
Yeah.
And that did happen in this case, and that was very helpful.
Yeah, a lot of people don't document those things, right?
Correct.
So later on it's, well, we're not sure what exactly happened. What are some of your rights? You have a right to medical treatment, correct?
Absolutely.
What are some of the other rights you have when you're injured?
Well, you have a right, obviously, to seek counsel, and we advise that you do that immediately, because if you don't, you're going to have insurance companies, adjusters who are going to be knocking on your door, trying to take your statement one-sided. You may be on medication, you may be in pain, and they're not there to help.
Now let me ask you, I've been involved with some automobile accidents. Insurance companies call up what happened. You're not under testimony, you're not under a threat of penalty or perjury or whatever. You give a statement, they try to use that against you, don't they?
Yes.
How does that have any legitimacy if you're not under oath taking a statement versus being under oath?
It's a prior statement, and if it's inconsistent or if it's not fully or properly explained.
So they use it to impeach you?
Yes, exactly.
In cases like this, you have a severely injured client. How do you take all your cases? When you take a case, you're ready to go to trial no matter what it takes, right? How do you know when you've reached an area where you could have a good settlement?
For me, as I like to tell the client, you're the boss, but what I like to see happen, and we talk about it, I want it to be enough to make a difference in your life, to actually make a difference in your life. If it doesn't, and we think that the case has merit, my recommendation will be to try the case.
When settlement is possible, I like a process too that's known as mediation. And a mediation session is a little more formal way for both sides to express themselves and see if they can't work together to a common solution. And I like to use that process of mediation.
And they also that is often done through a mediator who has handled a lot of these cases, correct? Do you find insurance companies willing to sit down at the table and mediate, or are they just being there for the heck of it?
Some of both.
Some of both. It all depends on the insurance company, right?
Yes, I think, and you may have had different experiences, but
it depends on both sides. Both sides have to be willing to mediate, and usually everyone is willing to mediate. When it comes down to the crunch, it may be that they don't want to pay as much as should be. Yeah. But I've had a number of successes using that.
Tim's case is currently on appeal, isn't it?
Yes.
Okay. Well, I want to thank both of you for being on the program. This is a great verdict. We certainly hope it's upheld. And we'd love to have you back again. Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.